Hello everyone, I'm Debujit Das and welcome to Courts Today by LiveLaw, your daily roundup of the most important judgments and hearings from across India's courts. So, let's begin. Starting with a much-awaited conclusion to the Hindenburg-Adani saga, the Supreme Court has now given a clean chit to Gautam Adani and his companies. SEBI told the court that after an extensive probe, it found no evidence of stock manipulation or round-tripping of funds through offshore entities, as had been alleged by Hindenburg in its 2023 report. The court made it clear that while Hindenburg's allegations were serious, no credible proof was brought before the regulator or the court. The Chief Justice stressed that suspicion, no matter how strong, cannot be the basis to damage reputations or destabilize markets when regulators have thoroughly examined the matter. With this, the Supreme Court has effectively shut the door on litigation arising from one of the biggest corporate controversies in recent memory. Moving on to another significant ruling, the Supreme Court has refused to modify a bail condition imposed on 85-year-old P. Varavara Rao in the Bhima Koregaon case. Rao had requested permission to move permanently to Hyderabad, citing worsening health and the fact that his wife had relocated there, leaving him without family support in Mumbai. Senior advocate Anand Grover highlighted that Rao had even suffered a fall from dizziness and that his monthly expenses of 76,000 far exceeded his pension of 50,000. Grover also noted that in Hyderabad, Rao would have access to free medical care, unlike in Mumbai, where treatment costs are a lot higher. However, the court was unmoved. Justice J.K. Maheshwari emphasized that the government will provide necessary medical care in Mumbai and that Rao's trial proceedings are still in early stages. The bench dismissed the plea, confirming that the restriction requiring Rao to stay within Greater Mumbai unless he obtains express permission from the trial court, remains part of his 2022 medical bail order. Moving on, in a major sports law development, the Supreme Court has finalized the constitution of the All India Football Federation. A bench comprising Justice Narsimha and Justice Bagchi approved the new governance structure after extensive consultations with FIFA, state associations, and other stakeholders. The court's order addresses long-standing litigation over AIFF elections, disputes involving state associations, and questions around eligibility and office bearer tenure. It incorporates key reforms to ensure transparency, accountability, and democratic functioning within Indian football governance. The judgment effectively provides AIFF with a stable legal framework, paving the way for smooth functioning of the federation, fair elections, and compliance with the National Sports Code and FIFA regulations. This move is expected to strengthen the institutional structures and bring stability to Indian football administration. A public interest litigation has been filed in the Supreme Court seeking an independent court-monitored investigation into the crash of Air India Flight 171, which killed 260 people, including passengers, crew, and persons on the ground on June 12, 2025. The petition filed by Safety Matters Foundation, an aviation safety NGO led by Captain Amit Singh under Article 32 of the Constitution, alleges that the manner in which the probe has been conducted violates the fundamental rights to life, equality, and truthful information. According to the petition, the Aircraft Accident Investigation Bureau issued its preliminary report on July 12, 2025, attributing the crash to fuel cutoff switches being moved from run to cutoff, thereby suggesting the pilot error. The petitioner has also flagged a conflict of interest, noting that officers of the Directorate General of Civil Aviation dominate the investigating team, even though the DGCA itself is under scrutiny for regulatory oversight lapses. Such an approach, it is argued, undermines public trust in aviation safety and could harm India's credibility under the standards laid down by the International Civil Aviation Organization. The Supreme Court has issued notice to the Union Government, DGCA, and the Aircraft Accident Investigation Bureau seeking the responses to the petition. Next up, the Supreme Court has clarified that a High Court cannot grant anticipatory bail by recalling an earlier order that dismissed the plea. The matter arose from Madhya Pradesh, where the High Court initially rejected an anticipatory bail application under sections 406, 420, and 120B of the Indian Penal Code. Later, the High Court attempted to revive the plea by recalling its dismissal order and granting bail. A bench comprising Justices Hrishikesh Roy and S.V.N. Bhatti held that this approach is impermissible. Once a detailed dismissal order is passed, the High Court becomes functus officio and cannot revisit the same plea simply to grant bail. The court noted that the Code of Criminal Procedure allows review in narrowly defined circumstances, but recalling a dismissal to reverse it falls outside the scope. Moving on to the next story, as in the Delhi High Court, a dispute has arisen over the allotment of government bungalows to Chief Minister Arvind Kejriwal. The petitioner challenged the centre's policy, alleging arbitrariness and political political motivation in denying Kejriwal the retention of an official bungalow reserved for former chief ministers. The centre defended its position, stating that the policy is clear. Sitting chief ministers are not entitled to retain bungalows meant for former office holders. Since Kejriwal continues to hold office, he cannot claim any special treatment or permanent allotment beyond the terms of the policy. The court observed that government housing is strictly regulated by policy, not personal expectations or political considerations. It directed that the matter be listed for detailed hearing with records of similar allotments to former and current chief ministers placed on file to ensure consistency and transparency in decision making. In a significant development, the Supreme Court has permitted certain public prosecutors and government advocates in Chhattisgarh to provisionally appear for the upcoming civil judge junior division preliminary examination, despite not being currently enrolled as advocates under the Advocates Act 1961. The Chhattisgarh Public Service Commission had previously denied admit cards to these candidates, citing the requirement that applicants must be enrolled as advocates on the date of the examination advertisement. This policy posed a challenge for government lawyers as their enrollment is often suspended during their tenure in official roles. A bench comprising Justice Vinod Chandran and Justice N.V. Anjaria issued an interim order directing the commission to allow these petitioners who possess the requisite qualification to appear for the examination without insisting on the enrollment condition. However, the court clarified that this interim relief is confined to the petitioners who approach the court and does not create any equities in their favor if they fail to meet any other eligibility criteria. In Rajasthan, the High Court has ordered a crackdown on dummy schools, institutions marking students present while they attend coaching classes. Justice Anup Kumar Dhand called it a blight on the education system and directed the government and education boards to form SITs for surprise inspections. Schools found colluding with coaching centers face derecognition. Boards must enforce a minimum 75 attendance rule for students from class 9th to 12th, and parents must be formally informed. The court also asked CBSE to re-examine 3 earlier de-affiliation cases with 4 weeks. And in Delhi, Yasin Malik has filed a detailed affidavit in the High Court opposing the NIA's plea, seeking death penalty in his terror funding case. Malik claims 6 successive governments engaged him in peace talks over Kashmir, including during the Vajpayee and Manmohan Singh years. He says his 2006 meeting with Hafiz Saeed was arranged at the Intelligence Bureau's request, and that he later briefed the Prime Minister and NSA, receiving thanks for his role. Malik argues this meeting has been distorted to build a case against him under UAPA. He also cites initiatives like a 15 lakh signature campaign in Jammu and Kashmir to show his commitment to non-violence. The High Court has directed him to file his formal reply by November 10th, as it considers NIA's appeal to enhance his life sentence to death. That wraps up today's edition of Courts Today. Subscribe to LiveLaw for credible and comprehensive coverage of everything important from country's courts. I'm Devojit Das. Thank you for watching.